your questions using the QA feature at the bottom of your screen. That way we can answer them for the group afterwards. And we generally don't monitor the chat, so we just don't want your questions to get lost in the chat. We will utilize that to drop helpful links and places to go to find some of these resources. Thanks, Erin.
Great, thank you, Amber. So good evening. Thank you for joining us tonight. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and I'm here to talk with you about the Connecticut Paid Leave Program. Tell you a little bit about the program and our authority, and then we'll focus on making sure that you have a good understanding of the Family and Medical Leave Act, as well as the Connecticut Paid Leave Act, and how they are similar and how they're different. We'll talk about the processes for applying for benefits under Connecticut Paid Leave, as well as the process in general for how you would apply for job protected leave from your employer under FMLA. As Amber mentioned, we do have some links and resources that we'll share with you, and we'll have plenty of time for questions. So just to jump right in, let me tell you that the Connecticut Paid Leave Authority is a quasi-public agency, so that means we are a public entity with a public purpose, but we are a little bit more nimble than a traditional state agency, which is helpful because we had a lot of work to do in less than 2 years to get the program stood up and ready to start administering claims for benefits, which is sort of our primary function is administering those claims. But in addition to that, we also are statutorily required to receive the contributions that are set forth in statute and to make sure that those contributions will pay those benefits. There is a process for employers who want to offer an alternative way of complying with the Connecticut Paid Leave law. They can offer their employees a private plan that is equivalent to or better than the program we offer. And we are responsible for reviewing those applications and then auditing the private plans. We also do a lot of outreach and engagement efforts. We really want to make sure people understand the program, understand their entitlements. And so that is a major function of what we do. Just some things to be aware of, right? Contributions began in January. So as of January 1st of 2021, you should have seen a change to your paycheck. 0.5% of your wages should have been deducted from your paychecks, and those get sent over to the authority, and that's what funds the program. The Connecticut Paid Leave program is entirely employee funded. Starting tomorrow, we are going to begin accepting applications for benefits. So that goes live tomorrow. We're starting to receive those applications tomorrow, but benefits won't be paid until January. Under the statute, benefits begin as of January 1st, but we wanted to open the doors a month early so we can smooth the process and make sure that people, particularly people who are going to be out on leave in January, can start receiving their benefits sort of at the beginning of the time, as opposed to having to wait until January 1st to both apply and start receiving the benefits. The first question is sort of the threshold question: am I a covered employee under the Connecticut Paid Leave Act? Do I work for a covered employer? The short answer is most likely yes, you are, because most employers in the state of Connecticut are considered to be covered employers. They are required to participate in the program. If you work for an employer who has one or more people working here in Connecticut, you're most likely covered. Covered employers include nonprofits. It also includes private sector employers with unionized employees. It even includes domestic workers. So if you work for a family, particularly as a home health aide or some other domestic employment, that is still covered employment. Our program also allows sole proprietors or self-employed individuals to choose to opt in. So if you work for yourself, you're an independent contractor perhaps, you are not required to participate because you're not an employee, but you are allowed to choose to enroll if you want to. If you do enroll, you have to stay in the program for 3 years at a minimum. And since you don't earn wages, the 0.5% deduction comes from your self-employment income as opposed to your wages. Some people work for a sole proprietor. So the sole proprietor is the business owner. They may have a few employees. They have to enroll as an employer because they have employees, and then they can choose to opt in for themselves. There are certain employers who are not covered. This is by statute. The federal government is not subject to Connecticut laws, so if you work for the federal government, you're not covered. The state of Connecticut is sort of a hybrid. We're not covered except as to our covered public employees, which I'll define in a second. Municipalities and local or regional boards of education are not covered under our program. So if you work for a town or you are a teacher, you're not covered unless you meet the definition of a covered public employee. And finally, non-public elementary or secondary schools are also not covered. These are the same entities, except for the state, who are not covered under Connecticut FMLA either. Then there are some other laws, generally federal laws, which say, these are entities that are not subject to Connecticut state programs. Railroad workers, for example, there's a federal law which establishes a sick leave program for railroad workers, and that supersedes Connecticut law. Similarly, if you work for the government of another state or a sovereign nation, so Mashantucket or Muskegon, you're not subject to Connecticut employment law. So they're not part of our program. There are two situations where the employer may be covered, but you as an employee are not. And that's where if you are someone who is an interstate trucker who works in Connecticut but lives in another state, you don't pay income tax in Connecticut. And you would also not participate in the Connecticut Paid Leave program because the contribution is considered to be a type of tax. So you wouldn't be subject to that contribution. You couldn't participate in the program. Similarly, there's a federal law which says that the spouse of an active duty military member who opts to continue paying taxes in their home state instead of in the state where they're currently deployed, they're entitled to make that choice. But if you've made that choice, say you're from Florida, but your spouse is deployed to Connecticut and you've moved here to Connecticut, but you're not paying Connecticut taxes, you wouldn't be participating in our program. If you choose not to pay Connecticut taxes, and if you're not going to contribute, you can't apply for benefits either. If you are either an interstate trucker or a spouse of an active duty military member who's not paying taxes, you already know that. So this part shouldn't come to a surprise to you. All right, I told you that certain state entities are not covered unless they're covered, which is just classic legislative speak, right? But a covered public employee is a public employee who may be covered by the statute, and that includes non-unionized employees of the state of Connecticut. So managers, appointed officials, legislators, judges, we're all non-unionized, and so we are considered to be covered under the statute. We do contribute to the program. Unionized employees of the state can collectively bargain to be included in the program. And if they do so, they'll start contributing and could apply for benefits. Employees of municipalities and employees of local or regional boards of education are not covered right now. But if the unionized employees of either the town or the board collectively bargain to be included, then everybody, union and non-union, would be considered to be a covered public employee at that point in time. Okay, so if you work for a covered employer, you should be paying contributions. Your contributions are 1/2 of 1% of your wages. And when we talk about the wages, we mean the calculation that your employer uses for calculating your FICA obligations. The reason we use the FICA definition is because the statute says that the contributions are capped at the Social Security contribution limit, which is also and you use the FICA definition to determine Social Security contribution limit. Right now, that limit is $142,800. So you would contribute up to 0.5% of your income up to that cap until you hit your salary of $142,800. And your employer is going to take that deduction out of your paycheck and then send that money to the Paid Leave Authority. The payments are remitted to us on a quarterly basis, and they go straight into the Paid Leave Trust. Now, the money is used only and exclusively for the purposes of the Paid Leave program. So to run the program and fund the benefits. It's not considered state money and cannot be used for any other state purpose. Okay, so you know that you're covered employer and covered employee and you remit contributions. So what is this all for? Well, the whole point of this is to make sure that you have income replacement if you have to take leave for certain qualifying conditions. Now, the ability to take leave is governed by FMLA, or the Family and Medical Leave Act. Now, technically, there are two different laws. There's a federal FMLA and a Connecticut FMLA. These are the laws that allow you to take job-protected time away from work for qualifying reasons. Now, both of these laws say that leave taken under FMLA is unpaid. So the employer may adopt a policy that allows for the employee to receive some sort of income replacement during the leave, but there's no mandate to pay you while you're out on leave. Some employers are really generous and will continue your regular pay if you're out. More often, the employers may require you or allow you to use your earned accruals, so your sick leave or vacation leave and the like, while you're out on leave. But the law itself says that leave is unpaid. What you get is job protection. Now, Connecticut FMLA is going to change very significantly next month, and I'll tell you how in a few minutes. Then there's Connecticut Paid Leave. So CTPL, or Connecticut Paid Leave, is a law that says an employee who can't work because of certain qualifying reasons can receive income replacement so that they don't have to go without a paycheck while they're out of work. We talk about it as CTPL. Sometimes people talk about it as PFML, or Paid Family Medical Leave, but we really think that can create confusion between FMLA and CTPL, so that's why we use CTPL. It's important to note that CTPL does not provide job-protected leave. We just provide the money if you're out of work. All right, so in both Connecticut Paid Leave and FMLA, you have to be out of work for a qualifying reason, and the reasons basically are the same. The first one, the one that's used most often, is medical leave. So if you're out for your own serious health condition, so you're incapacitated by your condition or you need to receive treatment for your condition, that's considered medical leave. And that includes being pregnant or serving as an organ or bone marrow donor. There's also bonding leave, which is leave taken to bond, emotionally and physically with the new child in your family, either through childbirth, adoption, or foster care. You should note that both mothers and fathers can take bonding leave, right? Both mothers and fathers are parents, and so they can both bond. And you can bond at any time within the 12 months after sort of the baby or new child arrives in your family. For adoption and foster care, you can also use bonding leave to take time away for all of those appointments and meetings that you need to do to process the adoption or foster care placement. Then there's also caregiver leave. Caregiver leave is when you, the worker, have to take time away from work to care for a family member who has a serious health condition. You don't have to be the one, providing the physical therapy or, intubating them. But you could just be there to provide physical care. It could be to provide psychological care and comfort. It could be to take them to the doctor's appointments, but you're caring for the person who's sick. Then there's something called military caregiver leave. And military caregiver leave is a subset, and that is when your parent, spouse, child, or next of kin is in the armed forces and they've been injured in the line of duty on active duty. You can take this special military caregiver leave to care for them. There's also qualifying exigency leave, which is also for military families. This is leave taken if your parent, spouse, or child is on federal active duty or has been notified of an impending call to duty. And you can take this qualifying exigency leave to attend to specific listed reasons that are associated with the call. Perhaps it's arranging for a power of attorney or getting a will, or maybe going to a sending off ceremony or a welcoming home ceremony. So there's a list of qualifying exigency reasons that you can take this time off. Then there's family violence leave. Now I left that to last because technically family violence leave is not officially part of FMLA. It's a separate Connecticut statute that says an employee who is the victim of family violence can take up to 12 days in a calendar year to seek medical care or psychological care, associated with the family violence, to obtain services from a victim services organization, to relocate if they need to do that because of the family violence, or to participate in any sort of court proceeding associated with the family violence. Now, the Family Violence Leave Act says it's 12 unpaid days in a calendar year. And under the Connecticut Paid Leave Act, an employee could receive income replacement benefits from the authority for those 12 days. Oh, I want to tell you a little bit more about caregiver leave, because caregiver leave under federal FMLA is limited to caring for a parent or a spouse or a child under 18, or a child who's over 18 who has a disability that prevents them from engaging in certain activities of daily living. And that used to be the definition under Connecticut FMLA. Apologize for the phone. But with the new Connecticut FMLA, the caregiver leave is actually much broader. You can take caregiver leave under Connecticut FMLA to care for a parent, spouse, son or daughter of any age, as well as a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity, whose close association is the equivalent of one of those family relationships. So you've got a nice broad circle of people for whom you can take caregiver leave under Connecticut FMLA and receive income replacement benefits while you're out on leave. So parent, spouse, child of any age, sibling, grandparent, grandchild, I think those are definitions we pretty much understand. Although I'll note in Connecticut, those definitions also include in-laws. But this idea of a person who's related by blood or affinity is somewhat new to Connecticut. It's a definition that the federal government has used for years in connection with things like bereavement leave, sick leave, and other states and municipalities have used it as well. But it's relatively new for Connecticut. But basically, it's a recognition that families come in all shapes and sizes, and it may not be a family that has sort of a legal bond associated with it. It's your chosen family. So it's going to be fact specific. The employer or the authority could ask you for a simple writing, so a simple written statement from you explaining how this person that you want to care for is the equivalent of your parent, spouse, your sibling. They can't ask you for notarization. They can't ask you to produce family videos or photo albums, but they can ask you to explain the nature of the relationship and how it is the equivalent. And these are things that I think we'd all kind of recognize. For example, in my family, my great aunt really stood the place of my grandmother. She died when I was 3, but my great aunt, who lived to be over 97, came to every family event. She went to school concerts. She came to every holiday. And we took care of her. We went grocery shopping for her. We took her to the doctor when she got sick. When she went up into the attic when she wasn't supposed to and broke her hip, we were the ones who were there to make sure she was okay. She was the equivalent of a grandmother. And so under this new entitlement, or this new related by affinity, I would be able to say, look, great aunt was like my grandmother. The other thing where I think this is really going to come into play is for people who are in a significant relationship with someone who's not their legal spouse. Connecticut doesn't recognize common law marriages. So up until now, you could be a longtime companion of somebody, but if you didn't have a wedding certificate or marriage license, you would not be able to take FMLA leave to care for them. But under this new definition, that unmarried significant other with whom you maintain a spouse-like relationship is the equivalent of a spouse, and you would be able to take Connecticut FMLA to care for them and receive benefits from Connecticut Paid Leave Authority. Now, when I talk about leave, I just want to make sure we, again, use all the same definitions. A block leave is a continuous absence for a single qualifying reason. So you break your leg, you're going to be out of work for 4 weeks. The full month of January, you're out. That's a block leave. Maybe you need to take a reduced schedule leave. So you can still work, but you have to work 3 days a week instead of 5. Or maybe you need to leave work every day at 2 instead of at 5:30 because you have to care for a family member. That's a reduced schedule leave. And then there's intermittent leave. Intermittent leave is leave taken in separate non-consecutive time periods rather than a block or a reduced schedule. You could have intermittent leave because you have a condition that kind of comes and goes. Maybe you have Crohn's disease, so you have flare-ups, and when you have a flare-up, you're out. You know, you're not going to be seen for another 12 hours, but then you're better and you go back to work. Or things like qualifying exigency leave, where the purpose of the leave is to attend, you know, sending off ceremonies or family briefings. You go out for a couple of hours, you come back to work. That would be intermittent leave. So we've talked about who's a covered employer. We've talked about the leave reasons. Let's talk about when you're eligible to either receive job protected leave or income replacement benefits. The three different laws that we talked about each have three different eligibility standards. For federal FMLA, to get job protected leave under that statute, you have to show that you were employed by your employer for at least 12 months and that you worked at least 1,250 hours in the 12 months immediately preceding leave. And your employer either has to have 50 or more employees or be a public or governmental agency of any size. So you don't get federal FMLA unless you've been there for at least a year and you work at least 50%. So a extensive part-time or full-time worker. And it has to be a relatively large employer. With Connecticut FMLA, starting in January, the eligibility requirements are a lot more generous. You only have to show that you were employed by the employer for at least 3 months immediately preceding the leave. And the employer is one of those people I talked about. They're someone who has one or more employee. There's no hours worked requirement for Connecticut FMLA. This means part-time workers, seasonal workers could become eligible for Connecticut FMLA now, whereas in the past, they probably would never meet the requirements. With Connecticut Paid Leave, because we're focused on the income replacement, we actually don't care how long you've worked for any particular employer. We focus on how much money you've earned. We look to see if you've earned at least $2,325 in your highest earning quarter, looking at the first 4 of the most recently completed 5 quarters. So if you wanted to receive income replacement benefits in January, we would look at the income you received at the end of 2020 and sort of from January through the end of September of 2021. If you earned at least $2,325 in any of those quarters, and you are either currently employed by a covered employer here in Connecticut, or if you're unemployed, had you been employed by a covered employer here in Connecticut, at least at some point in time in the 12 weeks before you apply to us, you'll be eligible. Now, as I mentioned, sole proprietors can opt in. They would have to show they also earn the $2,325 and that they're living here in Connecticut. So if you're eligible, you get a certain amount of job protected leave. Federal FMLA says it's 12 weeks in a 12-month period for all those leave reasons I mentioned, except for military caregiver. They actually give you 26 weeks of leave there. For Connecticut FMLA, it's also 12 weeks in a 12-month period. This is one of those changes I mentioned. It used to be 16 weeks in a 2-year period, but as of January, it's going to be 12 weeks in a 12-month period. But you still get 26 weeks for that military caregiver for the person who's injured in the line of duty. And then, as we mentioned, the family violence leave says it's 12 days. Now, another new thing for Connecticut FMLA is that a person who is experiencing incapacity during pregnancy can get an extra 2 weeks. Say they have to go on bed rest before the baby's born, or maybe they just need to go to those prenatal visits and they can't schedule them around their work schedule. They could use those extra 2 weeks during the pregnancy and still have 12 weeks remaining. For Connecticut Paid Leave, you can get income replacement benefits for up to 12 weeks in a 12-month period. Now, that's true for all those leave reasons, including military caregiver. So even though you get 26 weeks of job protection, we can only pay 12 weeks of income replacement. As I mentioned, there are 12 days for the family violence and the 2 additional weeks for incapacity during pregnancy. All right. So that's kind of a really fast overview of the benefits that you might be able to get. Let's talk about how you can actually access those benefits. For Connecticut Paid Leave, the real connection is between you, the worker, and us at the Paid Leave Authority with AFLAC, which is our claims administrator. We would ask you as the employee to submit an application to us at least 30 days in advance if you know they're going to be out on leave, or if you don't know, as soon as practicable. So if it's a baby, we would want to know 30 days in advance. If it's, hey, I just broke my leg, we would say, okay, contact us as soon as you can. You'd have to submit your application. We'd have you create an account with us so you can track your application. And there is some supporting documentation you have to provide, and you have to let us know when you're out and if you're getting any other money that we should be taking into consideration. And there is a statutory requirement that you notify your employer that you made a claim with us. We would review the claim and pay the benefits, monitor it. If we deny it, you can request reconsideration. We are on the lookout for fraud. We got to keep this fund solvent and have it available for people who actually need it. And so we will investigate fraud and impose penalties as appropriate. Your employer doesn't have a whole lot to do with the Connecticut Paid Leave stuff. They will have to complete and submit an employment verification form that you would give to them once you've made a claim with us and that they would send to us. We might need them to validate absences or other sources of money on a case-by-case basis. And as we'll talk about, they should be telling you what their paid time off policies are so that you know what to expect. Employers are not allowed to discriminate against you or retaliate against you because you're exercising your statutory rights. That's just a given. And the Connecticut Department of Labor would hear appeals relating to denials of claims or if we impose penalties. So if we deny a claim, we can't resolve it through the reconsideration process, you can always go to DOL and file an appeal with them. So what does this look like? Well, as I said, we're going to start accepting applications tomorrow, but those are applications for benefits for absences that will be occurring in January or after January 1st. We're not going to pay any benefits until January, and the benefits are associated with leaves that happen in January. The easiest and best and fastest way is to go through our online portal. But if you can't access the portal for some reason, you can submit your claims by telephone to the AFLAC call center, when there are ways to submit documentation through email or mail or fax. So on our website, if you go to ctpayleave.org, there's a button for prepare to submit a claim, and we walk you through the process. That's actually going to change tonight, and it's going to have more information after tonight because we're going live tomorrow, but it's going to look pretty similar to this. There is step-by-step instructions for creating your account. There is a short video that you can watch to kind of walk you through the process, and you'll be off and running. You could also call AFLAC directly, but basically you tell us, all right, I need to be out because of my own serious health condition. I need to be out for caregiver, whatever it is. And we'll walk you through the steps in terms of the documentation you need to provide. And you tell us, all right, I'm going to be out for 3 weeks, starting on February 12th. It's going to be a block leave. I've got 5 jobs, and these are all my employers. AFLAC, as our claims administrator, will validate that information and make sure that you work for a covered employer and review the documentation you provide. If you're missing anything, they'll let you know what it is and give you time to correct it. If we can approve the claim because you're a covered employee for a covered reason, we will calculate the benefits using data we can get from the Department of Labor, as well as some information from you if necessary, and we'll issue benefit payments to you. Now, the benefits are going to be issued via electronic transfer, so directly to your bank account, or through a stored value card, basically a debit card that we can re-up. Plan is to issue the benefits every Tuesday on a weekly basis, but 2 weeks in arrears. So for example, if you're out the week of January 2nd through the 8th, the benefits will be paid on Tuesday the 18th. This extra time just gives us the time to make sure that it's calculated properly, that there are no offsets, there's no other factors that we would need to take into consideration. And then you're out, and then you tell us, okay, well, I'm going to be out longer than I expected. My doctor wants me to stay out for another 2 weeks, or I'm feeling great and I'm going back to work 2 weeks early. If you're out on intermittent leave, we're going to ask you to let us know about those absences as they occur, because they may not be planned. So you just let us know when they happen. And you would do that through the account that you create with us. Now, the benefits are set in statute, or at least the formula for calculating the benefits are set in statute. And how much you get really depends on how much you currently earn. So we look at your base weekly earnings and determine that by looking at your highest 2 quarters from the first 4 of the 5 most recently completed quarters, and divide that by 26, and that becomes your base weekly earning. If that is less than or equal to the minimum wage times 40, your benefit would be 95% of that amount. If your base weekly earning is more than Connecticut minimum wage times 40, so more than $520, you'll get 95% of $520 plus 60% of the difference between how much your base weekly earnings are and $520. However, in all situations, the maximum you can get is 60 times the Connecticut minimum wage, which right now would be a maximum benefit of $780. I don't know about you, but when I hear people describe mathematic equations, I get a little fuzzy. So I want to tell you that on our website, there is a benefits estimator. You could go in and say, okay, I get paid $520 a week. What was my estimated benefit going to be? It's an estimate because we would need to know, are you going to be out a full week? Are you going to only be out 60% of the week? Is your employer going to be paying any money? But it's a good way of kind of getting a sort of general sense of what your benefit would be. And if you fit into the 95%, the 95 plus 60, or if you're going to be capped at the 60 times Connecticut minimum wage. One of the reasons that we can't really say that the estimate is necessarily how much you're going to get is because we need to know if your employer is going to pay any income replacement while you're out. Now, as I mentioned, the employer is allowed to either require or permit you to use your employer-provided paid time off while you're out on FMLA leave. Under Connecticut FMLA, if you're taking Connecticut FMLA, the employer can't require you to exhaust all of your PTO. They have to give you the option of keeping at least 2 weeks of your paid time for other purposes. Maybe you have a cruise scheduled for later in the year, so you want to save your accruals for that. They have to let you hold on to 2 weeks. So what are your options? Well, if you have no paid time or you're not required to use it and you choose not to, then you'll receive your CTPL benefits for the full period of the leave. So you're out for the full month of January, so you get Connecticut Paid Leave benefits for that full month of January. Maybe your employer requires you to use your paid leave, and you have enough to cover the full amount. So you have 8 weeks of vacation on the books, or sick leave or whatever, and you're only going to be out for 4 weeks. Well, if your employer requires, or you choose because you want to get your full wages, you'll get your PTO, and that will give you the income you need while you're out on leave. So you're not even going to touch your CTP leave benefits at this time. That full 12 weeks remains available to you in case you need them later. Maybe you only have enough paid time off to cover part of your leave. Maybe you have 4 weeks total, and you're holding on to 2 weeks for some other purpose, and your employer says, okay, well, I want you to use your sick leave for those first 2 weeks, and then you'll start getting Connecticut Paid Leave benefits for week 3 and 4. Your employer is allowed to require that. That works for you. You're still getting income replacement while you're out on leave. And then you could have a situation where Your employer is going to pay you for part of your leave. Maybe they offer you a short-term disability insurance policy that they own that's available to employees, and it covers 60% of your leave. Maybe it's a sick leave bank that pays 50%, whatever it is. Or maybe you know that you earn more than $720 a week. You want to use your accruals to top off the benefits you get from the authority. All of those situations are allowed. The only rule is that the combination of Connecticut paid leave benefits and employer-provided benefits cannot exceed 100% of your regular wages. So in the employment verification form, we're going to ask your employer, is this employee receiving any income replacement benefits? And if so, is it simply to top off or supplement the benefits the authority provides? Or are you, the employer, the primary payer, in which case we'll modify and adjust our benefits to make sure that you don't get up more than 100%. If you're trying to figure out what you're going to get from the Connecticut paid leave, you need to know what your rules are at your job for how you use your PTO. Does your employer require you to use your PTO when you're out on leave? Will they allow you to? Are there any rules about it? So maybe the employer says you have to use your sick leave for your own serious health condition, and you're not allowed to use sick leave for bonding, or you can only use it for 2 weeks of bonding. Whatever the rules are, you need to know from your employer, so you should ask. And if your employer provides short-term disability insurance, you want to know what that policy says. A lot of policies say they're the payer of last resort, so you have to use up all your employer-provided and state-provided benefits before you tackle that. Maybe it's a long-term disability, so you have a 6-month waiting period before you can even touch it. So you want to find out what that policy says. If you went out on your own and bought your own private insurance from Aflac or Colonial Life or whatever, on your own, maybe the employer let Colonial Life come and talk to you at work, but they're not paying anything toward your benefit. It's your own personal insurance policy. We don't care about those. Those are paid for by you for your own purposes. They're not employer provided, and so we wouldn't take them into consideration when we look at how much your benefits will be. Okay, so that's Connecticut paid leave, the income replacement side. Connecticut Paid Leave Authority doesn't have any official responsibilities about Connecticut FMLA, but after doing this training for a year, we know that it's helpful to people to have a comparison and see, how does Connecticut FMLA work? Well, the big difference is Connecticut FMLA is primarily between the worker and the employer. That's the connection. The employee will apply to the employer for the job protected leave. They may ask you to complete a written application. They're probably going to ask you for documentation, a medical certificate or something of the sort. And they may have attendance and call-in policies that you have to comply with, even if you're out on leave. So you work with your employer. Your employer should be establishing those policies. There is a poster that they are required to post, technically not required until July, but we are working with DOL to create a poster for them to put up now. But they're the ones who are going to process your requests, monitor your usage, and return you to work. The Connecticut Department of Labor is responsible for promulgating regulations to explain the sort of FMLA rules and providing guidance to workers and employers. And if you have a complaint against your employer, say they denied you your FMLA or they failed to return you to your job after you went out on leave, you would submit your complaint to the Department of Labor. How does this work? Well, you need to let your employer know that you need time off from work for a qualifying reason. You don't have to say FMLA. If you know it's FMLA, go ahead and say it's FMLA. It'll make life easier. But you have to let them know enough information that your employer can understand that, oh, this sounds like a caregiver leave under FMLA. This sounds like a serious health condition. Again, 30 days in advance if the need for leave is foreseeable, as soon as practicable if the need is not foreseeable. Once you tell the employer that you need this time off from work, your employer has to tell you if you're eligible under Connecticut FMLA or the other laws. They have 5 business days to tell you this, and they should be providing you with a form. It's called the Notice of eligibility and rights and responsibilities. This is not leave approval. This just says, yep, you're eligible, and here are all the rules. You need to provide us with this documentation. You need to call in, whatever the rules are. They have to provide that to you. It's a standard form that they should be giving. As part of it, they're going to say, this is the documentation you need to provide, and this is how much time you have to give it to us. They should give you at least 15 calendar days. If you are having trouble, maybe you're having trouble getting the doctor to fill out the med cert, you should tell your employer that you're having this trouble within those 15 days. And they are required to give you additional time, a reasonable amount of additional time, but you have to let them know you need it. Once you give them the documentation, they have to review it, determine if it's complete or insufficient. If it's insufficient, they have to explain what's missing and give you time to fix it. If it's complete, they have 5 business days to tell you if your leave is approved or not. If it's not approved, they have to tell you why. If it is approved, they have to tell you, okay, we're going to make you use your sick leave, but not your vacation. We're going to let you use this, but not that. They're going to tell you if you need to report in. Maybe you have to call in every day or once a week. And if it's for your own serious health condition, they can ask you to provide a fitness for duty exam, saying that you're able to come back to work upon your return. Now, if this was a foreseeable leave, hopefully all of the process, the med certs, the approval, happened before you actually go out. Or maybe it's an intermittent leave, so you're going to be out a lot over the next period of time. When you take your FMLA leave, you have to report into the employer and saying, okay, I'm in labor. I'm taking my leave now. Or, I have that approved intermittent leave to take my mom to the doctor for her serious health condition. I need to go out on Friday for that. You can't just disappear, and you can't just say, oh, I'm sick. You want to connect it to your FMLA. And your employer is going to track the time to make sure that you're not exceeding the 12 weeks. Now, the whole kit and caboodle about FMLA is that you have job protection. They can't move you to a different job when you come back. You have the same right to return to the same job under the same terms and conditions when you return from leave. Now, if something happens completely outside, maybe it's a seasonal job and the golf course closes in October. Well, the golf course closes in October. They don't have to keep you on just because you were out. But they can't say, oh, well, we had a temporary worker while you were gone, and we really like her a lot better. No, they have to return you back to the job. That's the really big, important thing. And they can't penalize you because you had to take leave. They can't, refuse to consider you for promotions, anything like that. Now, if you're out for your own serious health condition and you can come back to work, but you need some accommodations, maybe you have a lifting restriction for another month, they have to work with you to accommodate that. Now, that's usually considered a requirement under the Americans with Disability Act or the Connecticut Fair Employment Practices Act, but it's connected enough to FMLA that it's important for you to know that you have that right to say, hey, I can come back to work, but I need some accommodations, I need some modifications, and they have to work with you on what would be a reasonable accommodation. A couple things to remember: even when you're approved under Connecticut or federal FMLA, you still have to follow your employer's attendance and call-in policies, and you need to talk to your employers and let them know when you're taking your FMLA. You do have to let your employer know that you or provide them with the appropriate documentation. It's the same documentation we're going to be asking you for. So the med cert or the validation that you've adopted a child or whatever it is. As I mentioned, there may be other laws beyond Connecticut FMLA, like federal FMLA or the Americans with Disability Act, or the Pregnancy Non-Discrimination Act, that apply to your situation. And finally, I think it's really important to know that even if for some reason you're like, oh, don't call this FMLA, I want to save my FMLA time, it's actually your employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. This protects you because it makes sure that you get that job protection that is the whole point of FMLA, and it protects the employer from a claim that they somehow interfered with your rights. So they're going to say, no, this is FMLA, we're calling it FMLA. As I mentioned, we've got a lot of information on our website that some of it's listed as being sort of for the employer, but really it's for everybody because we give the employer's information to share with you. So if you want to skip the middleman, go check it out yourself. We've got posters, we've got cards, we've got toolkits, we've got fact sheets. So there's lots of information on our website. There's also videos that we have both on our website and on our YouTube channel. If you go to YouTube and look up Connecticut Paid Leave. We have tons, I think hundreds of frequently asked questions so you can get information there. And if you're still confused, you can contact us through the Connecticut Paid Leave the ConnecticutPaidLeave.org portal. Now, this Contact Us portal is really for sort of general questions about the Connecticut Paid Leave program, of the general rules. If you have a specific question about a claim that you've already filed, you would submit that question to AFLAC through the portal or through the phone number. But if you have general questions about the program, you could reach us through the ConnecticutPaidLeave.org and use the Contact Us. You'd submit your question, tell us if you want an email back or a phone call back, and we would accommodate whatever you asked for. So ConnecticutPaidLeave.org, make it a favorite, bookmark it on your computer, tell your friends. I can't tell you how many times I've been just at the store walking the dog and kind of get into a conversation with people and find out that they are going to have knee surgery or that their mother is sick or something's going on. And it's like, oh, you need to know about this. This is useful information. So please share this information with your friends and families. Speaking of sharing, I'm going to stop sharing and check to see if anyone has any questions for us. If you do, please go ahead and put them into the Q&A. We'll wait a moment and give you a chance to ask those questions. If you don't, that's perfectly fine. As I mentioned, we will be sharing the link to this recording as well as the slide deck, and you can always go back and submit your questions later through ctpleave.org.
All right, Erin, it sounds like we have a quiet crowd tonight.
Sounds good. Well, check us out. Tell your friends, and thank you so much for giving us your time this evening. We hope that this was helpful for you. Have a good evening.
Thank you, Erin. You as well.
Bye-bye.